awesome guests have been doing a great job in answering them. Sonny, let me go to you on, and this is such an interesting question in terms of the court dynamics and what really goes on inside that courtroom, because we are human beings, and when we see it on TV, it looks a certain way. It's kind of a dress rehearsal, kind of a play, if you will. So Munch, I think it's M-O-N-C-H from YouTube. Would the judge call recess if he notices the jury being antsy or falling asleep?
Yeah, sometimes the judge might say, we probably need to take a little break. But usually they're focused more on what is happening, the other dynamics. And the clerk might motion to the judge that people are falling asleep. But
yeah,
that can happen.
Yeah, and my experience, Bridget, I'm sure you've seen this as well as Sonny, is the judges of, like I said before, a very powerful figure. And why is that? Because the jury looks at the judge as the person that doesn't have an interest in the game, that they're the arbiter between the defense and the prosecution. And the judge is always giving them something. The judge is giving them their breaks and their lunch, and the judges are always so kind, typically speaking, most judges, to the jurors. So the jurors really look up to the judge. That's why you don't want to get a judge's ire in front of that jury unless you really have to. But judges typically are very, very responsive to jurors who may be tired or antsy, or they may not feel well, or things of that nature. So Inquiring Mind from YouTube asked kind of an additional question. Inquiring Mind asked, this case is too much for this judge. That's the opinion of this individual person. You can comment on that if you'd like. And the second question is, how are judges selected for big cases?
Mm-hmm. That's interesting. So let's go to if this is too much for this judge. I'm not really sure exactly what we mean there, but when we say is it too much, I don't think it's too much for him. I think he's handling it actually quite well. He has made sure that he has reined in or any issues that the prosecution may have brought up, or even the defense counsel. He's making sure that everything stays on track. And he is very cognizant of what's going on. He rules on the objections immediately. He's making sure that he pays attention to everything that's going on in this particular case and to the jurors. So I think he's doing a great job. And so when we talk about if it's too much, I don't think it's too much. Now, how are judges selected? That may be a state-by-state thing, but here in Texas, where I am, the judges are selected at random. Really, whenever a case is presented to the district attorney's office and then it moves from the district attorney's office to an actual court, it is done at a selection at random. So there's not a way that it's just, oh, this judge is going to have that case. No, it's a random process, and it falls into this particular judge's court.
Yeah, okay, interesting. I want to go to a question. Jesselyn here from Twitter asked Sonny, what was the purpose of the plea deals when the state is not even allowed to mention the deals to the jury, and most defendants are allowed to plead the fifth? I thought the main reason behind offering them, I assume plea deals, was to get, quote, the head of YSL, Young Thug.
So when they offer them a plea deal, they're usually looking for something in return. There's some negotiation factors there. There's some additional information that they want. But plea deals are not unusual. They can be expected. This is a RICO case, and you usually want something, But if you don't get what you need, then the plea deals are taken off of the table. The individual has the opportunity sometimes to go back and say yes, usually before the trial starts, because afterwards, folks don't want to do that. But then in some cases, if the prosecution feels like they can, and the defense attorney wants to go and make that opportunity for them, but you don't necessarily want to talk about the plea deals, because if they have not been accepted, then it's almost like, in my opinion, they were not offered. So there's no need to have that discussion around something that was not taken.
Yeah, now I'm not sure exactly if I understand the nature of the question, but I will say this just so that we can round that out. Most courts have evidence rules that do not allow the discussion of plea agreements to be admitted into evidence. Again, it's one of those evidence rules because they know that that would chill agreements where they could resolve cases. However, when somebody does take a plea deal, and if that plea deal is to testify favorably for the government and the government uses that individual as a witness, it's almost certain that the defense attorney is going to be able to cross-examine that witness to say, well, you're only testifying favorably for the prosecution because of what they call expectation of benefit. You expect to get a benefit for your plea deal. So a plea deal that's not accepted or a plea deal that's offered as part of a settlement that's not accepted is rarely, if ever, admissible in a courtroom in general, unless there's a specific reason why it would be. But a plea deal that is accepted and then the person gets on the witness stand for the state, you can be assured the defense is going to bring it. In fact, you can be assured the prosecutor, a good prosecutor, is going to bring that out in direct examination because they know it's coming with the defense. I'm curious, Bridget, in terms of your thoughts as to whether or not I don't know if there were time limits, and this is a question that Nessie 1015 asked for each lawyer to present the opening arguments, but in my experience, typically speaking, most judges don't put time limits on. What should be the time limits? How do you as a lawyer make a decision as to how much is enough or how much becomes too much?
You're correct in that most judges do not put time limits on them, especially on a case of this magnitude. On smaller cases, let's say a DWI or something like that, assault that may be a misdemeanor, there will be judges that will put time limits on your voir dire or even your opening statements as well. And so that has happened. It's happened to me quite a few times. But in a case of this magnitude, the court generally doesn't do it because, again, there are so many witnesses that are going to be coming here. There's so much evidence. There's so many specific instances that these attorneys are going to be going over in this trial. And so they're not going over each specific instance in specific detail. They're just kind of grazing over it. And so the judge is giving them some free will and free reign here to go over it. I think every case is a case-by-case basis when we're deciding how long an opening statement should be. We don't want it to be too long to where we lose the jurors and they're not paying attention to us, but it should be enough to give them a roadmap of where we're going, what to expect, and what we're going to be seeing as we go throughout this trial.
Yeah, that's really great. So listen, I think we're going to take a break, but when we come back, if we do have time, there's a great question that Tallgrass is asking, and I want everybody to think about it before we take this break because it brings in a lot about nuance and evidence in the case, and that's this issue about whether or not we think the lyrics should be used against these artists as part of the evidence in the case. Artists, Bridget, we'll start with you.
So I'm a defense attorney, and I'm a defense attorney through and through. And when I say that I don't think that the lyrics should be a part of the record, I truly mean that. I think that it's a bit overreaching. Unless the state has exact evidence from the lyrics that tie to a particular offense, then it shouldn't be admissible. During our break, we talked about the difference between admissibility and credibility. And sometimes the judges, they will allow the lyrics in because they were saying that it is admissible because it's relevant, right? And it's up to the jurors to decide if it is in fact credible or related to what's going on in this particular situation. But I feel like it gives the state an opportunity to overreach, and they can bring in all the lyrics or conversations from different aspects that they choose to. Like, where do we draw the line at? Where do we say, okay, well, this is enough. That's enough. We shouldn't be bringing in additional evidence from a lyric or a song that may be completely unrelated. We have no idea what that means.
Bridget brought the fire in terms of denying the prosecution. I'm going to play the prosecutor role at some point in time, ladies, or maybe the judicial role, as I give Sonny an opportunity to answer the question that's being asked right now by Tall Glass, which is, do you think the lyrics should be used against the artists?
I think when the lyrics are used, because I've had this happen and I was working on the prosecution side, but it can be problematic in the sense that the jury may perceive the lyrics to be one thing. And when you think about rap lyrics, and you have to think about culture, you have to think about lifestyle, you have to think about reason and why these lyrics were created. And unless the jury can put themselves in that particular mindset to think about all of the nuances that are related to rap lyrics that they may or may not understand, I think it could play either it can play for the prosecution, against the defense, and be problematic for the jury.
Okay, I as the judge will sit here and say, I think this tall glass is a great question. It really gets down to our evidence rules, and the evidence rules is all evidence that's relevant is admissible. And if it doesn't make a difference whether or not you think it's right or it's wrong, unless under a Rule 403, the judge finds that it can lead to undue consumption of time or confusion of issues to the jury. What the judge is typically saying in cases like this is, I'm going to allow it to be admitted, but whether the jury believes it or not, you can make that argument to them down the road. At least that's how I see most judges ruling on a situation like that. But these ladies certainly have presented both sides of an argument because it can be abused. But you know what? That's the defense attorney's job to do, to say that it in fact was abused. So that is a great question that brings us to evidence rules and the practicality of what happens in a courtroom. The evidence gets in, one side gets something, one side doesn't get something. So it's so important to know your evidence rules. Ladies, we got couple more great questions here. So let's go to Christina from YouTube. She asks, if the ones who took plea deals don't testify, will their deals be revoked? Now let's, for purposes of assuming this question is that the plea deal that they took required them to testify truthfully in court. So I'm going to modify that a little bit to say if ones that took plea deals to testify truthfully in court don't testify, Bridget, what happens to their plea deals?
Well, so whenever someone takes a plea agreement, then they are telling the court, because they haven't taken the plea in front of a judge, that they are going to abide by the terms of this particular plea agreement, right? And so they are saying to that judge under oath, I'm going to abide by the terms of this agreement. And so if they choose not to do so, then yes, then the state can change whatever that agreement is down the line through a hearing, right? If they are going to do that. And so it is they should be abiding by the terms that they want to continue to have the benefit of that plea agreement, or for the state to abide by the terms of what they said they would be getting.
Yeah, Sonny, I think you're going to probably pretty much agree with that. And the only reason I'm going to ask you is that I got 2 speed round questions for you ladies before we end the show. But would you like to amplify on that answer, or are you going to stick with it?
I stick with I agree with Bridget's everything.
All right.
On point.
All right, ladies, got 2 speed round questions. We got about 60 seconds to answer them. GME to da moon. GME to the moon. Okay, ask, how much money will this trial cost taxpayers? An estimate, Sonny?
At least $20 million.
All right, how about you, Bridget?
It's a 6-month trial. It's going to cost quite a bit of money.
Okay.
It's a lot.
Yeah, it certainly will. Okay, we got 1 minute left, ladies. So Tall Glass again from YouTube is going to ask, I'll start with you, Sonny, do you feel the case was charged correctly?
Well, based on what they have presented so far, I believe that RICO fits what law enforcement and the prosecution has said.
How about you, Bridget? I got about 15 seconds.
I do think it was charged correctly. It's now up to the defense counsel to show that it is not enough for a conviction.
Yeah. It's very, very difficult when you're making these charging decisions. You bring a RICO in, you're bringing in all sorts of conduct. But to the question that had been asked before, you can make it very confusing for a jury, and prosecutors don't want jurors to be confused. Ladies, thank you for those excellent questions. I know it's hard to answer things that are on the spot like